Now you got 12 people in a jury, you got a prosecutor, you got a judge, and you've got a client. And you're doing the same thing for every single one of those. And you're also doing it for the people that in your perception you can see in the gallery. Because you're literally like, I would literally be watching, and I would literally be able to tell from like the farthest perception that the prosecutor was moving his chair to make an objection. You know, because it's hypervigilance. Tyson said it's like everyone has a plan until they get punched in the face, right?
Right.
And I love that because like your whole case, like you've got a plan, but what happens if there's something that the other side has that and criminal law is like that because you don't know what they've got, you know.
And sometimes a witness is going to say something that you didn't expect.
Right.
And you may not have gotten you don't always get full discovery of everything they will testify to like you might in a civil trial.
Right. They won't even give you what the co-defendant's statements are. You don't have a right to those.
And it's so brilliant that you brought up that Tyson story because
Which story?
The Tyson story.
Oh, Tyson.
Because in a criminal case, you are going to get punched in the face once or twice an hour by something you
Everyone,
didn't expect.
like we're criminal defense attorneys, right? We are the consummate underdog, and nobody wants us to win except for our client, you know?
Right.
Like, think about the OJ trial. Think about OJ, right? Like, how bad do you want OJ to lose, you know? And you know he did it, you know?
Charlie, I've often said one of the things that I think makes you a badass criminal defense attorney and makes any criminal defense attorney a badass is you revel in being the underdog. You have to, because to your point, you're going to go into court, and if you think, yes, everyone who passed 6th grade civics knows that you're innocent until proven guilty, but if you believe for a second that those deputies, judges, prosecutors, and all the police officers who are there to collect evidence are not all on the same side, you haven't really sat in a courtroom.
And we now have, 250 years of jurisprudence that have slowly tied the arms behind the back of the defense attorney and the defendant.
Well, now we're going through some of these things, and when you're thinking through all these things, and the Commonwealth goes and they put on all of their evidence, do you ever make objections, and what do you normally make objections about?
During trial?
During trial,
Okay.
during the Commonwealth's presentation of evidence, what's a normal objection you might make, and why might you do that? And then, more importantly, answer why you might choose not to.
This is, and I'm still learning. I'm not sure if I would even count myself as an expert trial attorney even just yet. The way I look at it is, so you have to know, and this is a David Ball lesson that was taught to me. You need to be able to state your theory of the defense succinctly in like 2 sentences. Very easy. Why is he not guilty? Why is he not guilty? In a way that does not like armor up the jury, you know? And so you need to have a really clear theory of the defense.